Recently, Cyprus has been condemned by the European Court of Human Rights in the case of M.A. versus Cyprus, which originated in an application submitted by a Kurdish Syrian national back in 2010, when at the time we managed to secure for the first time in Cyprus an interim measure under Rule 39 of the court, suspending his deportation to Syria. This came along with another 38 applications in the same circumstances that we managed to suspend deportation under the same rule. And of course, there are another 38 applications currently pending at the European Court of Human Rights. What this decision basically says is that Cyprus does not have an effective remedy when it comes to challenging Article 2, which is the right to life, and Article 3, which is inhuman degrading treatment, torture and inhuman degrading treatment claims, because the procedures providing for a remedy before the courts are not automatically suspensive, which means that even though a person has the right to challenge a decision denying their asylum claim, and even though a person may challenge the decision against a deportation contrary to Article 2 or 3, it does not have automatic suspensive effect. The court rejected all the arguments of the government of the Republic of Cyprus because they tried to say that in practice this may be respected, but the same way like in other cases like against Greece or Turkey, where the same arguments were brought forward, they have been rejected by the European Court of Human Rights. Moreover, the court held that there is not an effective remedy also against decisions for the detention of migrants, because a recourse to the court it takes too long. Whereas also it touched upon, but it didn't conclude on the scope of the judicial review, which is very limited in Cyprus. Therefore, it found that there was a violation also as regards effective remedy in terms of Article 5 as well. And it also held that there was illegal detention because the applicant was detained for 11 months, even though deportation orders could not be enforced because of the interim measure of the European Court of Human Rights. So it found that there has been a violation also of Article 5 in terms of the duration of detention of the applicant. This case is very important as regards the protection of asylum seekers and the protection of people claiming that they would face torture and human degrading treatment if sent back to their countries of origin or other countries where they cannot find protection, because it comes down to criticizing the whole system of remedies available in Cyprus as not effective, and this is something that we have been saying all along. We've tried to litigate that through the domestic courts. It didn't work. Now we have the European Court of Human Rights condemning Cyprus about that. Therefore, it puts the burden and obliges the Cyprus government to actually review the whole system in terms of the effectiveness of its remedies. After this decision, the Republic of Cyprus is under the obligation under the European Convention of Human Rights to comply with the decision of the court. Therefore, it is expected that they have to provide for automatic suspensive effect in terms of challenging before courts any decisions on deportation or asylum decisions, and also to rethink and review the whole system as regards remedies against illegal detentions of migrants pending deportation. This is the first time we had such a decision. Therefore, it is important, and also in another sense it's very important because as it is now shown that Cyprus does not have a system where the remedies are in compliance with the European Convention of Human Rights, one could also question whether Dublin rules may be enforced and send back asylum seekers in Cyprus, as we don't have effective remedies against deportations contrary to Article 2 or 3.